So watching him sort of in our limited interaction and scenes together, it was really cool to see him juggle that and how he was able to go in and out of like putting on the director hat and then being Ryle and then having to divorce himself from, you know, seeing maybe Lily and Atlas have a bunch of chemistry and having to take himself out of being Ryle and being the director. And I was like, man, that must be such a head trip to have to be like, wait, what?
I've got a new favorite judge. Too bad they're not based in New York, because this one clearly isn't buying what Blake Lively is selling. A magistrate judge in a California federal court just issued a ruling on Blake's motion to compel a motion she filed against a slew of third parties tied to Wayfair. She's been trying to force them to hand over documents, including one from Tara Hanks, a health coach who gave her probiotic recommendations after multiple rounds of antibiotics. Blake had teamed up with Wayfair on a joint motion asking to shift this whole thing back to New York federal court, even after the judge there already tossed it, saying he didn't have jurisdiction. But she argued that if it couldn't be transferred, the court should go ahead and compel the production of documents right there. The California magistrate didn't need a hearing to reach a decision. Instead, he reviewed the filings and responded firmly. He stated that Blake's request targeted 8 individuals she subpoenaed for documents connected to her consolidated New York case. But since these people live, work, or do business in California, any motion to enforce compliance has to be made there. So, he shut down the attempt to reroute things back to New York, saying there's simply no justification for that. And here's where it gets interesting. Blake had already told the court there wasn't any disagreement about the subpoenas themselves. There were no claims about them being improper, too broad, or lacking clarity. The only objection had been over location venue, which she argued should be New York, even though she filed the same motion in both states. As far as Blake sees it, the respondents are expected to turn over all relevant, non-privileged material without a fight. And apparently, those third parties feel the same. They've told her repeatedly that they're working in good faith to comply and plan to finish by July 1st, 2025. Bottom line, there's no real, active dispute over discovery at this point. When it comes to the document requests, there isn't actually a real disagreement between Lively and the respondents about whether they should turn over the documents, just about how quickly it's happening. And this part of the judge's ruling is honestly the most revealing. Lively isn't objecting to any refusal to produce specific categories of records. What she's really upset about is the pace, how long it's taking these individuals to gather materials, particularly from their personal devices. She wants the court to order immediate compliance or set a hard deadline within 10 days, arguing the respondents are stalling. But the respondents counter that the scope of what's being asked, along with the volume of devices, justifies the timeline. Their attorneys say everything will be handed over by June 27th, literally tomorrow or where. At the absolute latest, July 1st. Funny enough, July 1st is nearly 10 days from June 20th, the date she filed the motion. It's clear the judge picked up on this. He sees right through the urgency Lively is claiming. It's basically saying she's trying to rush the process just for the sake of rushing, even though the parties are already working toward the exact timeline she's demanding. And since there's no meaningful conflict requiring his intervention, the judge rules the motion to compel as premature denied if it's about moving the deadline up. But granted only in the sense that production must be completed by July 1st, as already promised. He's making it plain. This wasn't a matter of non-compliance, it's impatience. Just because she doesn't like the speed doesn't mean the court needs to step in. And he even adds a note stating that nothing in the order prevents both sides from extending deadlines in the New York case if needed, or from working together in good faith on rolling productions after July 1st. However, if they can't reach that agreement, then July 1st remains the final deadline. Ironically, that's the same date they already said they'd meet. So at the end of the day, Lively went through all of this filing paperwork, dragging people to court just to demand something that was already happening. And the price tag for this kind of filing is in the tens of thousands, with high-end lawyers billing between $1,500 and $2,500 per hour. Defending a motion like this just for the sake of urgency and cost Wayfair's legal team a staggering amount. The attorneys handling this case are managing multiple clients, so if they're representing 7 or more individuals, the legal fees add up fast, with rates between $1,500 and $2,500 per hour. Responding to a single motion to compel could easily cost Wayfair $20,000 to $30,000. That's why every time Lively files one of these unnecessary motions, it's not just a nuisance, it's expensive. Each filing means more time, more paperwork, and more costs. Thankfully, this particular judge didn't fall for it. He saw right through the tactic and made a quick, clear ruling. Honestly, I wish this case had been assigned to California instead. Judge Steve Kim seems far more competent than Judge Lyman. Anyway, following yesterday's video where we broke down the subpoena involving Van Zandt Inc., Janelle has now taken steps to force Van Zandt to release documents related to their company specifically, its internal structure and shareholders. Jen is trying to determine exactly who's tied to Van Zandt aside from Blake and Ryan, whom she suspects are using the company as a front. Her goal is to establish whether there's any connection at all between Van Zandt and Jones Works. And if none exists, it supports her claim that this was a bogus legal move. She's also pushing to get all communication between Jones and Jones Works and a full copy of the subpoena. The big question she's trying to answer: did Jones Works provide data before the subpoena, or only because of it? That's crucial to proving her timeline. What's almost comical is how Blake Lively's team responded. In a letter to the court, her attorneys, who were initially representing Van Zandt in this so-called action, claimed Jen's motion left out important details, essentially misrepresenting the situation. They argued that Jen and the other Wayfair affiliates have actually had the subpoena and the related documents since May 16, 2025. That's when they say a copy of the subpoena in Jones Works. Full production was given to them. They even attached Exhibit A as evidence. But here's the twist. The case is entangled in several other proceedings. There's the ongoing Lively v. Wayfair case, another involving Jones Works suing Wayfair, and then the now dismissed Wayfair v. Lively suit. All these overlapping cases are connected, which complicates the situation. That case hasn't been revised, and all parties involved are bound by a protective order. In the letter dated May 16th, which was attached to the filing, it states that Blake Lively intended to submit the materials as part of the Lively v. Wayfair and Wayfair v. Lively litigation. What she included wasn't the original set of documents, but a reproduction of what she received through the Jones Works subpoena, along with a copy of that subpoena. For example, some of the documents from Jones Works were missing specific attachments and lacked the metadata outlined in the jointly agreed ESI protocol, which governs how digital and hard copy information should be produced. While Lively's production aims to reflect the full set of metadata fields as laid out in that protocol, several of those fields remain blank because the original documents lacked that data to begin with. Additionally, some attachments are simply absent as they were not included in what Jones Works provided. Materials were submitted with a reservation of rights and with no waiver of the objections already stated. Furthermore, these documents have been stamped confidential and are restricted to use within the scope of this single legal action. They cannot be disclosed beyond the bounds outlined in the protective order. In other words, if Jen Abel views the subpoena under the Lively case, she's legally barred from using it in the Jones Works case. They are separate proceedings, and the protective order limits document use accordingly. This creates a clear complication that hasn't gotten much attention. Lively is asserting that, while she did receive documents from Jones Works, some came without the necessary metadata, and she's essentially saying that it's not her problem, it's simply how the files arrived. She's shifting the burden, arguing that their agreement requires metadata, but that she can't be faulted because it wasn't provided to her. And she maintains that these materials can't be shared between the two cases. So while Jen may have had a look at parts of what was received in Lively's attorney, LNGOP admits they've seen portions. They still don't have the subpoena needed for this particular suit. That subpoena could very well be classified as confidential, which would make sharing it across cases a violation. On top of that, Lively isn't addressing the fact that her letter doesn't clarify this key detail. It's explicitly stated that there were no emails or communications turned over between. Blake and Jones works nothing to explain how that exchange happened or how she came into possession of the materials. On top of that, the subpoena response from Blake included nothing about Van Zandt Inc.'s structure, no corporate documents, no shareholder info, nothing. Jen is still trying to establish who exactly is behind Van Zandt, who holds stakes in it, and what connections, if any, they have to Blake Ryan, or even Stephanie Jones. If no such links exist, or if Jones is completely unrelated, it strengthens Jen's argument that this was all part of a bogus legal setup. One especially important detail is the recurring concern that some of the evidence, particularly screenshots, might have been altered. Wayfair keeps pointing out that metadata is the key to verifying authenticity in court. Those hidden data points confirm who created a document, when it was modified, and whether it's legitimate. The credibility of the material can be challenged, and the risk of tampering becomes very real. Metadata contains important contextual data like timestamps, author names, and even where the file came from. If any of that is missing, then you can't tell when or how the files were extracted. For example, if a file shows up and it supposedly originated in August, but no subpoena was issued until October, that's a major red flag. Metadata should indicate that the information was pulled after the subpoena, so if the timeline is off, it creates a problem. Without clear metadata, Jen has no way to figure out if Blake received those files before or after the legal order. Any gaps in that chain of custody make it hard to piece together what really happened. And worse, if metadata has been deleted or altered, that might qualify as evidence tampering. In court, that's called spoliation, and it can completely discredit a case. A great example, if a healthcare worker claims they updated a record at a certain time, but the system's metadata shows a different timestamp, their testimony loses weight. Metadata doesn't just confirm timelines, it protects the integrity of the evidence and helps ensure that everything complies with legal standards. While not every missing field means wrongdoing, the absence or manipulation of metadata can create serious challenges when trying to determine what's real and what's not. Manipulating evidence or even the perception of it can cause serious problems in court because it throws the credibility of that evidence into question. What Blake is essentially saying here is, look, this is the material I was handed. And yes, some of it didn't come with metadata, but that's on Jones' works, not me. But that argument doesn't erase the fact that submitting files without metadata is a major red flag and could absolutely be challenged later on regarding whether the evidence is even valid. The big questions now are, did Stephanie Jones mess with the data? Were files edited? Were fake conversations inserted? Were dates changed? Jen's already deeply suspicious that Blake had access to this data well before a subpoena was even issued. So when Blake says, sure, there's missing metadata, don't blame me, blame Stephanie, it raises a major hypothetical. What if metadata was purposely left out to cover up that the info was passed along in August, not October? Entire case timeline relies on the story that the forensic data pulls happened only after the subpoena was issued. If that's true, the metadata should show the files were extracted in October or November. Any date showing August would blow that apart and raise the possibility that the data was handed over outside the proper legal channel. Missing or altered metadata doesn't just hint at tampering, it can suggest deliberate concealment. It's even worse. Maybe entire conversations were faked. That's why metadata matters, it's how evidence is verified. Under their ESI agreement, metadata is required, so anything missing, it could be tossed out, and if Blake has already relied on these materials in her filings, that could seriously damage her credibility. One point I find really telling, she's pressing that this material should already be available, yet the document specifically says it's restricted and can't be used outside the original case. So does Jen truly have access to it? Maybe parts of it, anything that wasn't marked confidential, but there's no clear indication what was or wasn't labeled that way. If there's missing metadata on those files, that might explain everything. Jen still doesn't know whether Blake received the documents before or after the subpoena was issued in. That uncertainty makes everything even murkier. The letter they sent doesn't resolve this issue, nor does it explain why Blake hasn't handed over any documentation about her own company to Wayfair. There's also a complete absence of communications between Blake and Jones Works, and no internal records about the business or the underlying action itself, which is exactly what Jen Al is looking for. Sure, there are fragments of what's needed, but Jen is still missing crucial pieces. What's most alarming is that the letter actually shows that some of the data given to Blake by Jones's Works was either manipulated, hidden, tampered with, or outright deleted. This is going to be a huge challenge for Wayfair, as figuring out exactly what went wrong will take effort and, without direct access to Jen's phone, it's nearly impossible to trace. That's likely part of the reason they wanted Edgeworth's data to pinpoint exactly when the file extractions were done. But let's speculate for a second. What if the metadata on the files Blake received had been deliberately wiped to hide the truth? I'm not saying that happened, but if it did, that would raise major red flags. Blake is pushing responsibility onto Jones's Works, claiming that if anything is missing or altered, it's not on her. But who would actually have the motive to hide the timeline? That would be Stephanie Jones, if she turned over the information. In August, well before any subpoena and the metadata supported that, then wiping it would conveniently erase that timeline. Could that be an attempt to dodge accountability or even breach a confidentiality agreement? Or was the data straight up manipulated? Whatever the case, this is a legal mess. Honestly, the Wayfair legal team has a monster of a job trying to unravel it all. Adding to the confusion, Blake's team keeps acting like Jen already has access to the materials, but does she really? Even if Jen's seen some of it, she still needs it for this specific lawsuit. And if the content can't legally move from one case to another, then she'll have to request it again from either Van Zandt or directly from Blake, neither of which this letter confirms. The back and forth games just continue. And now, there's a new twist. Judge Lyman, overseeing the Lively versus Wayfair and Judge Wallace matter, seems to be taking Jed Wallace's motion to dismiss very seriously. In a recent court order, Lyman appears ready to remove Wallace from the lawsuit due to lack of jurisdiction. That would be a major shakeup. If Wallace gets dropped, a big part of Blake's case goes with him. In a striking statement, Lyman wrote, "Lively may submit a letter no more than 2... Lively now has until July 2nd, 2025 to submit a 2-page, single-spaced letter limited only to addressing Wallace and street relations argument in their motion to dismiss." Their position? That Lively failed to name a specific co-conspirator who committed a concrete act inside New York that would trigger jurisdiction under Section 302A2. Wallace's legal team had already asserted they aren't subject to the court's reach under the long-arm statute, not even through the lens of a conspiracy theory. But this particular jurisdictional angle was fully laid out only in their reply brief, which is why the judge is allowing Lively to respond. Then, Wallace's side gets 2 pages to reply. His defense was never in New York, and none of the events linked to him happened there. Lively's lawsuit references acts that span multiple states, New Jersey, California, New York, basically, wherever she happened to be. She filed it in New York because that's where she lives. And she's trying to establish diversity jurisdiction to tie the multi-state parties together. But when a defendant argues the New York court has no authority over them, like Wallace just did, then she has to prove it should. And right now, Wallace is pointing out that she never accused him of taking any action that specifically occurred. In New York, that's a problem for her. She hasn't shown that Wallace communicated with anyone in New York, or that he directed any behavior toward the state. It looks like the judge is weighing this carefully, and Wallace could actually be removed from the case altogether. If that happens, it would hit her case hard. Wallace is the one she's pegged as the mastermind behind the so-called invisible smear campaign. He's the digital puppet master she claims built the narrative machine. Without him, there's no architect, no retaliation, no conspiracy. The rest of the people, Belen, Heath, Nathan, and Jen Ayler, based in California, Wallace's own communications were either internal within California or connected to Texas, where he resides. And Nathan, also not in New York, he didn't interact with Blake, and Wallace insists he only spoke with Nathan again in California. Wayfair is also a California-based company, so the puzzle pieces don't fit New York jurisdiction. The judge is giving Blake one final shot to link someone's New York-based actions back to Wallace. But unless she can prove that Tanfast is likely out, and if he's tossed, it could collapse her claims entirely. My gut says Judge Lyman is skeptical of everyone right now. He's probably looking for a way to cleanly eject this from his courtroom. That's just my read, so what do you think? You surprised this whole thing might be falling apart for Blake? Drop your reactions in the comments. To like the video, hit subscribe if you haven't already, and turn on that bell so you don't miss what happens next. Thanks for watching. See you in the next one.